Insurance companies will take actions to try to pay you the least amount possible for your car accident injury claim. I know this because I spent years working on behalf of insurance companies in Kentucky defending personal injury claims in Kentucky courts throughout the state. To win your Kentucky car accident case, there is certain proof you must have if you want a big payday. To illustrate how to win a Kentucky car accident case, let me tell you the story of my past client, Tiffany. I was at my home office one day in the fall of 2020 when I got a call from Tiffany. I was working remotely solely from my home office due to the COVID-19 pandemic. Tiffany informed me she was injured in a motor vehicle accident. She was driving straight on a 2-lane road when someone pulled out in front of her from a side road, fishtailed, and struck her vehicle, knocking her vehicle off the roadway into a brick sign on the side of the roadway. She was transported by ambulance to the hospital. After being discharged from the hospital and getting subsequent medical treatment, an MRI about a month after her accident revealed that the most significant injury she sustained was a tear of her rotator cuff in her right shoulder. After conservative treatment did not stop her pain, she underwent surgery to fix the tear in her right shoulder. This was followed by a couple months of physical therapy. After I signed Tiffany up as a client, myself and my staff immediately got to work on her case. We tracked down surveillance footage that caught the car accident on video. Liability for the accident clearly rested with the other driver. It was obvious after watching the video. To win a car accident injury case in Kentucky, the first thing you must prove is liability. While we had an easy time proving liability against the other driver in Tiffany's case, that's not always the case for everyone involved in a car accident in Kentucky. Fortunately though, Kentucky is what is known as a pure comparative negligence state. Pure comparative negligence, also known as pure comparative fault, is a legal doctrine used in Kentucky to determine how damages are allocated when multiple parties share the blame for an accident or injury. Under this doctrine, each party's degree of fault is taken into account when calculating the amount of compensation they are entitled to receive or liable to pay. In a pure comparative negligence system, even if one party is found to be primarily at fault for an incident, the other party's contribution to the incident's occurrence is still considered. The damages awarded are then adjusted based on the percentage of fault assigned to each party. This means that even if a person is 99% responsible for an accident, they could potentially recover 1% of the damages from the other party. For example, consider a car accident case where driver A was driving over the speed limit and ran a red light, while driver B was distracted and didn't brake in time. If it's determined that driver A is 70% at fault and driver B is 30% at fault, and the total damages for each driver total $100,000, then driver A will be able to recover $30,000, which is 30% of $100,000. And driver B will be able to recover $70,000, which is 70% of $100,000 from driver A. Different jurisdictions may have variations of comparative negligence rules, but Kentucky fortunately has pure comparative negligence system, which is the most plaintiff-friendly system that exists in the United States. Now, back to Tiffany's case. After we tracked down the surveillance footage that caught the accident on video, my office gathered all of her medical records and bills and gathered proof of her lost wages for her time missed from work. You see, after proving liability in a Kentucky car accident injury case, you must prove the amount of your damages caused by the car accident. In Tiffany's case, she was eligible to receive compensation for her medical bills, lost wages, and pain and suffering. We were able to show that Tiffany incurred at least $70,000 in medical expenses after we gathered her medical bills. We were also able to get her employer to fill out a lost wage verification form, which showed Tiffany incurred around $40,000 in lost wages due to her time missed from work. I then sent a demand letter to the other driver's insurance company along with all of the evidence we gathered in support of Tiffany's claim, including her medical records, medical bills, the video of the accident, photographs depicting bruising throughout Tiffany's body, and the lost wage verification form that showed the amount of her lost wages. We demanded the insurance company pay the policy limits. The insurance company delayed providing us with a response to the policy limits demand, so I filed a lawsuit. This got the insurance company's attention. They hired a defense lawyer and quickly agreed to pay out their insured driver's policy limits of $100,000. But we weren't done. You see, Tiffany was driving a vehicle that had underinsured motorist insurance coverage on it. Underinsured motorist insurance, also known as UIM insurance, is insurance coverage you can purchase on your car insurance that protects you financially and anyone in your car in the event the person that caused an accident with you does not have enough insurance to cover all your damages. So after we settled the claim with the other driver's insurance, we pursued our claim against the underinsured motorist insurer, who we had also sued in the lawsuit I filed. We attempted a couple of rounds of negotiations with the UIM insurer, but we soon realized that the UIM insurer was not willing to make a fair and reasonable offer. So we continued litigating the case. We answered written discovery questions and requests sent over by the UIM insurance carrier. We also had the UIM insurance carrier answer written discovery questions and requests that we had sent over to the defense attorney they had hired. The defense attorney for the UIM insurance carrier took Tiffany's deposition. In her deposition, Tiffany was able to explain all the pain and suffering she had experienced during this time, including things like being in a great deal of pain, but also not being able to engage in some of her hobbies, nor cook, clean, or do some of the chores around the house she would usually do. We also produced additional evidence we were able to gather throughout the litigation process. I communicated with the UIM defense attorney on several occasions. After months of litigating the case through the court system, we were finally able to come to an agreement to settle the UIM portion of the case. The UIM portion of the case settled for $165,000, bringing the total settlement for Tiffany to $265,000, meaning she received around $150,000 for her pain and suffering damages. Tiffany and her husband were happy. Winning a Kentucky car accident case is not always easy. Insurance companies will lowball you and try to get you to accept a low settlement. It happened in Tiffany's case. We had to push the case forward through litigation to finally get a fair and reasonable offer. If you can prove another driver was the cause of your accident and that you sustained injuries that required you to incur medical bills, lost wages, and pain and suffering, you are entitled to fair and reasonable compensation. Do not let the insurance companies win. Show them that you are a fighter and will only be willing to settle your injury case for a fair and reasonable amount in light of all your damages incurred as a result of the accident. The thing is, just because you now have all the evidence you need to win your Kentucky car accident case, it does not mean the insurance company will offer to pay you a fair and reasonable amount on your injury case. You see, it is often the case that you must file a lawsuit to get paid more on your injury case. And in this video about to pop up here, I'll tell you why filing a lawsuit usually gets you paid more in your injury case. Lastly, if you've been injured in a car accident, slip or trip and fall incident, or dog attack incident in Kentucky, remember to don't wait, call Tate.